Hello, everyone. I'm Suzanne Taylor, a partner in the Financial Services Regulatory team here at Shoosmiths. Welcome to our fifth podcast in our series of 8 podcasts about compliance and risk management. We've been exploring various aspects of compliance and risk, and today we'll be delving into the ongoing advice needed in order to operate a compliant business and manage risk effectively. We'll be discussing the concept of compliance advisory and what that means in the context of compliance and risk management. We'll focus in particular on the different times that a business might need compliance advice, and we'll also look at changes our clients can make in how they deal with compliance advice in order to best run their business. Today, I'm joined by my colleague, Simon Barnes, who will be sharing his insights and experience with us. Hi, Simon.
Hi, Suzanne.
Nice to see you. So I guess as a starting point, Simon, advisory can mean lots of different things to lots of different people, can't it? So what types of advisory support might clients need over the course of their business lifecycle?
Yeah, I think you're absolutely right that compliance advisory in practical terms means inevitably different things to different businesses. Different businesses come across different compliance risks, some big, some small, some frequent, some rather infrequent. And businesses need to find ways of rising to that challenge and managing them. But fundamentally, it's all about risk management. Now, risk management, of course, is about identifying the risk in the first place, assessing that risk. Is it a big risk, small risk, likely risk, not very likely risk? And then based on that, and in the broader commercial context in which that risk arises, working out how best to manage and mitigate that risk. Now, what is the risk in concrete terms? I mean, again, it varies slightly, but fundamentally and typically, it's risk of enforcement by regulators, it's risk of conduct that could lead to litigation, people challenging, and then it's all the associated cost, burden, reputation issues that go with risks if they do arise. So it's about identifying and managing those risks. I'm a competition lawyer. A typical question that will come to me in a compliance advisory context is either a business saying, we want to do X, is that okay? And if so, how should we do it? Or occasionally, we've already done Y, was that okay? And did we do it the right way? I'm very conscious though, Suzanne, you work in a very much an FCA regulated world as a financial services lawyer. I think over and above the sorts of queries that I'll have as a competition lawyer, which is, can we do this? How do we do this? I think in an FCA world, life is a bit more prescriptive, isn't it?
Yeah,
There are certain things businesses need to jump through.
Absolutely. I think you mentioned there the concept of we want to do X, how do we do it in a compliant fashion? And I think with the FCA, that's taken to a whole new level. I mean, to even start operating an FCA authorised business, you need to make sure that you are accepted into having an FCA authorisation, and that requires you meeting that standard from day one. Otherwise, the FCA simply will not approve your authorisation. The FCA talks a lot about being ready, willing and organised to run that business. And actually, what I think we see across all of our sectors is that clients aren't always ready, willing and organised to perhaps launch in an entirely compliant fashion when they do launch that new initiative.
Yeah. The FCA piece is quite an interesting one to somebody who's not an FCA expert, in that it does strike me that businesses that are in that financial services space, there are pros and cons to this, but they do have a regulator who is very heavily involved, very prescriptive, and they have a very much an ongoing, regular series of check-ins, I suppose. Absolutely. Is that right, with the FCA? Which, whilst from a sort of administrative burden, one could say, well, that's not ideal, that's all quite burdensome. But I guess it at least means there are the checks and balances and the ways of checking in with the regulators to whether they agree and got an issue, which in many areas of regulatory and compliance work, there isn't that ability. In most areas of the law, it's a question of self-assessment, forming your own view as a business as to what you think is the appropriate way to proceed, which may be the zero risk way, or maybe the way that has a moderate level of risk but an acceptable level of risk, but then proceeding in the hope that you're not challenged. And that is part of the commercial dynamic. But without the ability to check in with the FCA, I think you do have that relative luxury. Or am I being much too rose-tinted in the way I look at that?
Yes, I think some of our clients would say, I think it has its plus points and it has its negative points. There is a huge amount of data that has to be submitted. The FCA will run that through AI, and it will then supervise a firm based on what it's seeing from that data. Do firms necessarily get the answer from the FCA? No, not usually. But absolutely, it's really clear the standard that the FCA wants a firm to meet. And actually, interestingly, what you mentioned in your introduction of that three-pronged assessment of how you build a risk and compliance framework to identify the risk, assess the risk, and mitigate the risk.
Yeah.
Actually, in FCA businesses, we normally go 2 steps further. So we then say monitor and test.
Yeah.
So actually, you can demonstrate that your mitigations are, working to manage that risk. And then number 5, to then assign someone within the company who is responsible for the assurance framework around that risk. And the FCA actually expects to see those things in place before you even get authorised. So that's the level of assurance that the FCA expects to see. And anyone working in the advisory sector in the financial services space is very much advising on that framework to ensure that their clients are set up to operate in a compliant fashion.
And it's interesting because that framework that you've just outlined, of course, makes sense from a compliance advisory perspective for all businesses, because it's all very well setting things up, but monitoring and having the feedback and the responsibility for checking makes a lot of sense. It's interesting in the FCA world, by the sound of it, it's prescribed by the regulator.
Yes.
In most other areas of compliance and regulatory, it's for businesses to recognise for themselves. Actually, this makes sense.
Yeah, absolutely. And it helps us do business in the right way, which is a competitive advantage for us. Yeah, absolutely. I think you outlined in your first response there, Simon, that actually there's 2 ways compliance advisory can broadly come up. It's at the start of a new initiative, and it's perhaps when something hasn't quite gone to plan. So if we start with the positive, let's start at when we're launching a new initiative, a change to a business model. In my experience, there is a lot of focus often in a business when things go wrong, but perhaps there is less focus when we are launching a new model. And people are often really keen to launch, and that can take priority over putting a suitable compliance framework in place. What advice do you have for clients who are working with a change to business model, a new initiative, in order to make sure they set themselves up on the right foot?
Yes, I'm going to say something very obvious and very common sense, which is plan ahead. Inevitably, and I don't knock this for a minute, but inevitably businesses, when they have a new product, a new initiative, a new whatever it might be, commercially, of course, the business wants to crack on at breakneck speed as fast as they possibly can. Of course they can. And the first very important point I'll say is that as compliance advisors, and for these purposes, compliance advisors, you and I are external private practice lawyers advising clients, but it is the same principle that apply to in-house legal teams, if there aren't in-house legal teams, to management guiding businesses. We have a responsibility as compliance advisors to guide people, but our role ideally is not to get in the way. Our role is to facilitate what the business wants to do. And one thing I've definitely learned over the years is that most things that businesses want to achieve are perfectly achievable in a compliant way. It's just a question of identifying what the compliance issues are at the outset and identifying the ways in which the business can ensure it does comply. And sometimes that means a few tweaks here and there in terms of how things are structured, how things are presented, how things are recorded. But I find very rarely do you have to say no, which is good because none of us want to say no. Yeah. We're here to facilitate. I said it's about planning ahead, and as you said, very often, inevitably, the focus can be on picking up the pieces when things go wrong. The reality is that planning ahead is all about hopefully avoiding things going wrong and avoiding having any pieces have to be picked up, because it's a lot, dare I say it, cheaper and a lot less stressful for everybody, including the lawyers like you and me, if actually things are structured appropriately in the right place to minimise the risk of things going wrong, because nobody wants that.
Yeah, that's absolutely right. And actually, interestingly, whilst you were speaking there, we referred at the outset about how the FCA is so prescriptive. Actually, one of the things the FCA does is assign responsibility for different areas to different senior leaders within the business. And that can be a really effective way of holding people to account on delivering a new initiative or a change to business model in a compliant fashion. And actually, whilst I know that isn't necessarily the case across other areas of regulation, it is something perhaps our clients could look at even where they're not FCA authorised, because it's a great way of building that accountability.
Yes. And it is an interesting dynamic, again, between the FCA and non-FCA regulatory businesses, because the logic, whilst, okay, it may be administratively burdensome, I completely appreciate that, but the logic from an achieving compliance perspective makes sense. But businesses that don't have a regulator that prescribes that they do that have to ideally be sort of disciplined enough to realise it does make sense. Now, these things don't need to be hugely burdensome. It all depends. It's about being proportionate and commercial, but the logic definitely makes sense.
Yeah, absolutely. So if we then move to the second part, perhaps when something might be starting to go wrong, or you might have realised something hasn't quite gone to plan. I often find that this can be, for a organisation, the most high profile thing in their business because there's reputational risks. You've already referred to the risk of fines. What are the most important things to think about before we get to the stage of enforcement proceedings, etc., from a regulator when you think something might have gone wrong?
Yeah. I think the first challenge for businesses, quite frankly, is identifying when things might have gone wrong so that the issues are spotted, so that they can be assessed and managed, as we've talked about. And that does rely on the business having a combination of the appropriate systems in place, but also ensuring that the relevant individuals know the right things in terms of have the right information and awareness as to what the rules are, and that they feel empowered to raise them with the business, because it's all very well people understanding what they should and shouldn't do, but if the business culturally does not promote and encourage people to flag issues or even just ask questions and seek advice internally, the whole thing sort of can fall apart from a compliance perspective. To answer your question then, the question is, well, what if the business thinks something might have gone wrong? You mentioned these things often are very high profile. Of course, most potential crises that cross our desks as compliance lawyers, the number one objective is to keep it relatively low-key and nip the issue in the bud. I suspect, again, there may be a slightly different dynamic between you and your FCA world and me as a competition lawyer and other non-regulated industries. Because in my world, the reality is that some businesses do, and particularly individual members of staff, may do things that actually aren't ideal, maybe entirely suboptimal. Hopefully those get reported, they get managed either by management or by the legal team. Occasionally, the right thing to do is to go and voluntarily tell a regulator, like a competition authority or some other regulator, and deal with it that way. But at least 9.5 times out of 10, the right way of dealing with it actually is to manage the issue internally, do the right thing, put the business's house in order, draw a line in the sand, and then move on. Because at least then the business has the opportunity, feels confident it's done the right thing. And if somebody does ask after the event, at least it has a narrative there that it can point to having done a responsible thing.
Yeah, absolutely. That culture of compliance could be a whole different podcast, couldn't it? And I'm sure it will be picked up on one of our other podcasts. But it's absolutely fundamental. That culture of doing the right thing for your customers is so, so key.
Yes, actually, we've recorded a podcast on embedding compliance, which I've also spoken on, and we do touch on that about culture. And so we won't go into it now, but I think you and I will both agree that having that right culture of compliance, which is about people having the awareness, but also individuals within the business seeing that the importance and the dedication to compliance is supported by management, by legal, if there's a legal team, absolutely crucial.
Yeah, agreed. So looking ahead, Simon, let's look at some real practical advice for the people listening. Yep. What 3 changes would you recommend that clients could make with how they approach taking compliance advice internally?
Yep. Well, it all depends, of course, on where the business is starting from. I think you and I have experience, well, I know we have experience working for lots and lots of different businesses, big and small, a whole range of different industries. And almost without exception, those businesses, our clients, intend to comply. They want to comply. Their heart's in the right place, the motivation's in the right place, which obviously is a good starting point. In terms of the practicalities, the key starting point has to be having a combination of the right systems in place to manage compliant risks, spot issues and deal with them, but also ensuring that the right people have the right level of awareness, which will vary from person to person in terms of what they need to know about what level of awareness they need to have, but ensuring there is that awareness within the business so that issues can be spotted and reported. In terms of giving advice and compliance advice, be it for you and me as external lawyers, be it for house legal teams, be it for management, good compliance advice has to be given in the commercial context in which it arises. None of us can advise in a bubble without knowing the context. As I said before, compliance is not about getting in the way. Compliance is about hopefully achieving what the business wants to achieve, but doing it in the compliant way. And tell me if you disagree, but my experience is that is usually possible.
Oh, absolutely.
So most things are achievable safely. And I think my final point, which dare I say might sound a little bit glib, but I think you and I genuinely believe it, is that particularly at the outset of some new initiative, when something first hits the desk, first comes in through the door, The last thing that, in some respects, that the business commercially or past the business may want to do is consider the compliance angles, but a little bit of time and effort up front pays dividends, at least in terms of minimizing the risk of going wrong. And again, I'm going to use the word proportionate. Often these things need only a little bit of time and effort. Sometimes it may be much more significant and strategically relevant, but often, just a little bit of thought will be enough to set people off on the right path.
And it's so much easier, isn't it? In my world, I do a lot of product launches and making sure things are compliant when they come to market. So actually, how much easier is it to change something ever so slightly in how you build your system right at the start and get right to the end of the whole process and say, well, actually, it all needs reworking because it's completely not compliant. Absolutely. Get those people in the room on those initial discussions.
Yeah. But I'm going to say it again, those things only ever get considered if somebody raises it as something that needs to be raised. Now, some things inevitably, will cross the lawyer's desk and then it will be considered. But other things, you are relying on people in the business to have that little thing up here that sparks, I better check in with so-and-so to check whether there's any compliance issue here.
Absolutely. I could not agree more. And thank you, Simon. There's some really valuable insights there for our listeners. It's been an absolute pleasure speaking to you. For our listeners, if you want to find out more, visit our website where you can learn more about our compliance offering. And you can also listen to each podcast in this series. Thank you for tuning in. We'll be back with episode 6 soon, which will be about crisis management.